Welcome to Steamboat Institute's Campus Liberty Tour debate and discussion on making space for diversity of ideas. Should universities censor speech, and if so, on what basis? I'm Jennifer Schubert-Aiken, Chairman, CEO, and co-founder of the Steamboat Institute, which was established in 2008 for the purpose of promoting America's first principles. We welcome our audience here at the Dome at AMG National Bank in Greenwood Village, Colorado, as well as the nearly 500 people watching our live stream this evening from campuses and communities across America. Before we begin this evening's debate and discussion, I would like to take a moment to tell you about a few upcoming Steamboat Institute events. Our 13th annual Freedom Conference will be held August 27th and 28th at the Park Hyatt at the Beaver Creek Resort located near Vail, Colorado. Registration is now open at steamboatinstitute.org, and I'm pleased to announce that we are expecting a normal event this year with no COVID restrictions. We are very pleased to announce that our keynote dinner speaker for the Freedom Conference will be former Secretary of State Mike Pompeo. We will also be announcing many more speakers over the next few weeks, so please be sure to sign up for our email alerts at steamboatinstitute.org. Scholarships to attend the Freedom Conference will be available at steamboatinstitute.org beginning tomorrow with a June 30th deadline for submitting. These scholarships are awarded to college students and young professionals under the age of 30 who have demonstrated leadership potential and the ability to persuade others of the benefits of policies which promote individual liberty and free enterprise. So don't be left out. Register at steamboatinstitute.org and apply for a scholarship if you're a young leader. Our upcoming Campus Liberty Tour debates and discussions include a couple of events upcoming I would like to tell you about. April 26th at the University of Colorado's Boulder campus, Steamboat Institute will sponsor a discussion called Liberty and Justice for All, a conversation on social justice and identity politics featuring Jason Riley of the Wall Street Journal and Donna Brazil, leading Democrat strategist and Fox News contributor. Then on June 17th in Steamboat Springs, Colorado, we will host Backlash, How China's Aggression Has Backfired, featuring author and China expert Helen Raleigh, who will speak and do a book signing. Both of these events are free and open to the public and will be live streamed. You can find the registration details at steamboatinstitute.org. We are also planning a full schedule of debates this fall on campuses across America. So please follow Steamboat Institute on Twitter, Facebook, Instagram, and LinkedIn to get the latest updates. Steamboat Institute's Campus Liberty Tour debates are gaining in popularity and importance because of the increasing threat posed by cancel culture. While cancel culture seems to be taking over, Steamboat Institute takes the opposite approach, encouraging free and robust debate of even the most contentious issues. This is how students and all of us develop critical thinking skills and avoid falling into the trap of living in echo chambers. One of my favorite quotes is from John Stuart Mill: "He who knows only his own side of things knows little of that." As a 501c3 nonprofit, nonpartisan organization, Steamboat Institute depends on the generous support of many individuals, businesses, and foundations to bring you thought-provoking programs, including this evening's debate. I would like to thank the following major sponsors of Steamboat Institute's Campus Liberty Tour debates: Judy and Robert Newman and the Newman Family Foundation, Gary Cooper and Cooper Steele from Nashville, the Woodford Foundation for Limited Government, the Hatton Sumners Foundation, the Lined and Harry Bradley Foundation, the Anschutz Foundation, the Adolph Coors Foundation, the Jack Roth Charitable Foundation, the Snyder Foundation, and the Strake Foundation. And special thanks to Earl Wright and AMG National Bank for hosting us here at the Dome at AMC in Greenwood Village, Colorado. I would also like to thank our media partner, Media DC, which publishes the Washington Examiner, as well as the Denver Gazette and Ross Kaminsky, host of the Ross Kaminsky Show on K30K How and iHeartMedia, for helping to promote this evening's discussion. And now it's my great pleasure to introduce our speakers and moderator for this evening. Alan Dershowitz has spent his life defending civil liberties, defending free speech on college campuses, and defending Israel. He joined the Harvard Law School faculty at the age of 25, the youngest in Harvard history, and became emeritus professor after 50 years of teaching and 10,000 students. Professor Dershowitz has been called the winningest criminal lawyer in modern history. He continues to devote half his practice to pro bono cases and causes. Professor Dershowitz has published more than 1,000 articles in magazines, newspapers, journals, and blogs, and he has written nearly 40 books, including his most recent, Cancel Culture, the latest attack on free speech and due process. Professor Dershowitz is also the host of a daily podcast, The Der Show, where he takes on the hot political and cultural topics of the day and legal topics of the day. Professor Dershowitz has been a favorite speaker of our audiences at previous Steamboat Institute events, including giving the keynote dinner address at our annual Freedom Conference in 2019. Welcome back, Professor Dershowitz.
Thank you so much for having me. You know how much I love Steamboat and how much I enjoy participating in your events.
Thank you, appreciate that. Robert Post is Sterling Professor of Law at Yale Law School, where he served as the school's dean from 2009 until 2017. Prior to coming to Yale, he taught at the UC Berkeley School of Law. Professor Post specializes in constitutional law with a particular emphasis on the First Amendment. His 2009 book, For the Common Good, Principles of American Academic Freedom, has become the standard reference for the meaning of academic freedom in the US. He has published numerous other books and publishes regularly in legal journals and other publications. Professor Post serves on the editorial board of the new Journal of Free Speech Law, which will debut this summer. He also serves on the Oversight Board Trust, which was created to help Facebook answer some of the most difficult questions around freedom of expression online, including what to take down, what to leave up, and why. Welcome, Professor Post. Good to have you with us. And finally, our moderator this evening is Jillian K Melcher. Jillian is an editorial page writer for the Wall Street Journal, where she started her career as a Bartley Fellow at the Wall Street Journal Asia. Jillian was also the recipient of Steamboat Institute's Tony Blankley Fellowship for Public Policy and American Exceptionalism in 2015. Jillian has written extensively on issues related to campus free speech, highlighting the most egregious examples of censorship and cancel culture on campuses across America. I encourage you to read her philosophy statement at WSJ.com, which closes with, "I value kindness, courage, and loyalty, and I love a good cigar and a thought-provoking debate." And now let's get started with this evening's thought-provoking debate and discussion, making space for diversity of ideas. Should universities censor speech, and if so, on what basis? Julian?
Well, thank you guys so much for joining tonight. It's wonderful to see an audience here in person.
Not hearing.
Can't hear you, Jillian.
Can't hear you.
Can you hear me now? How about now?
Yes.
Beautiful. So now we're actually doing a real Zoom debate because somebody's forgotten to turn her mic on. And I see Mr. Post is taking advantage of the work from anywhere policy. It looks like you're on a beautiful beach somewhere.
I am. That's Angel Island in the background.
Fantastic. Well, I'm really excited to start tonight's debate. This is an issue that's become important not just on our university campuses, but for our society as a whole. And we have these two wonderful speakers, some of the most knowledgeable people in the field. And so to kick this off, I'm going to give them each 10 minutes to clarify their own position, to give you an idea of where they're coming from. And then we'll drill down on some of the issues here. I do want to remind you guys in the audience, you're going to have a chance to ask your own questions. So if you're here in person, check out the QR codes, scan it. I've got my iPad right here, and we'll be able to look through. And if you're part of our digital audience watching on Facebook, there should be a link there. So send your best questions for these two fantastic speakers. And without further ado, we'll kick it off. Mr. Post, I'm going to give you first opening statement.
Thanks so much, Jillian, and it's a pleasure to be here. And I'd like to thank the Steamboat Institute for this invitation to be in this wonderful, wonderful event. So I did tell the organizers of this event that it wasn't likely to be much of a debate, since it's very likely that Alan and I agree on the outcome to most cases. We're both very much in favor of protecting the freedom of speech of professors. And so I thought I would take my first 10 minutes to talk a little bit, not about concrete cases and particular cases and where we come out, but about the theory of why we might and might not regulate the speech of professors in universities. And it makes sense to me to focus on the question of why we might regulate and how we might regulate, for two reasons. The first is, if you look at concrete cases, it tends to get swept up in this partisan debate and the culture wars. It's cancel culture versus something else. It's left versus right, red versus blue, whatever. And it strikes me that when one gets in a debate that's in the force field of this kind of partisan disagreement, thinking stops, because one's investment is to get the other side. And I have no interest whatever in that. My interest in this is trying to understand the theory of the thing and why we would or wouldn't want to regulate the speech. And the second reason is that as one thinks about the regulation of professorial speech, one has to have a theoretical framework that tells you when it is appropriate and when it isn't. No one imagines that professors should be absolutely immune from regulation in what they say outside of the university. So the question is when and when not, and that requires an explanatory framework. And that will, the explanatory framework will give you some account of why. It will give you some account of the procedures you use. It will give you some account of the decision-making bodies that should make decisions like this, etc. So let me sketch two different accounts of why one might either protect or not protect the freedom of speech of professors. The first account is what I want to call the freedom of speech account. And by freedom of speech here, I mean something roughly associated with the First Amendment to the United States Constitution, which protects freedom of speech. Now, as a technical matter, the First Amendment applies only to state institutions, but the underlying point would be to apply the same kind of protections to professors that citizens would have as against the state, namely that they have a personal right to freedom of speech, and it shouldn't be regulated except under very highly restrictive and unusual conditions. That's basically the freedom of speech idea. Now, it may surprise you to know that even though we've had a First Amendment since 1791, there have not been any Supreme Court cases protecting a judicial right to freedom of speech, what we would now call the right to freedom of speech, until the 1930s. And during the 1930s, the court developed its theory of freedom of speech for the first time. And they developed it out of the work of Justice Brandeis. And they developed it out of the notion that we need freedom of speech in our country so that the government might be made responsive to the will of the people. In other words, we have freedom of speech in order to shape public opinion, and we have a government which is designed to be responsive to public opinion. So our freedom of speech makes the government responsive to us, and has a lot of implications when you begin to think of freedom of speech in that light. But there are three basic rules which define freedom of speech doctrine when we try to articulate what kind of protection should be owed somebody on this account. The first rule is that you cannot regulate someone's speech in a way that is content-based. The state or the regulator or the censor cannot engage in content-based regulation. Why is that? That's because in this country, public opinion is supposed to set the agenda for the state. The state isn't supposed to set the agenda for public opinion. And the prevention of content-based discrimination ensures that by exercising our right to freedom of speech, the state will be made responsive to what we want it to be responsive to. The second basic rule is that, as the court said in a case called Gertz, there is no such thing as a false idea for purposes of freedom of speech. Another way of saying that is what the court said in a case called Mosley. There is an equality of status in the field of ideas. Every idea for purposes of freedom of speech is equal to every other idea. Now, what does that mean? That's a very odd concept. Many people try to explain that under something called the marketplace of ideas, but actually marketplace of ideas doesn't explain that at all. Marketplace of ideas is the thought that we can advance knowledge by allowing people to speak critically and never censoring what they say. If you look in the United States, wherever we actually create knowledge, we're always censoring speech. No editor of a professional journal, for example, edits a journal based on the marketplace of ideas. And if you drill down on this thought that there's no such thing as a false idea, it would mean there's no such thing as a true idea. It would mean total skepticism. And what in the world does it mean to say every idea is equal to every other idea? That's not our experience. In our experience, there are good ideas and bad ideas. So what do we mean by saying there's an equality of status? That is due to the fact that as speakers, we are participating in our governance. So we have a political equality. The equality of ideas derives not from epistemology, not from the truth value of ideas, but from the political equality we all have to influence the shape of our public opinion. That's the underlying thought behind the second rule. And the third rule is you cannot compel someone to speak. The court has said many times, you can't stop someone from speaking and you can't make them speak. Well, why is it we can't make someone speak? The answer is we speak in order to make the government responsive to us. So if the government is making me speak, it's obviously not being responsive to me. It's developing a false idea of public opinion. So it makes no sense to allow the state to compel us to speak. These are three basic rules. If you don't have these rules, I mean, there are a lot of other rules in the context of the First Amendment. If you don't have these three rules, you don't have a freedom of speech-based notion of the protection of communication. So now let's look at universities. Do we apply these three rules to professors? The answer is obviously not. So content discrimination. I get hired to teach constitutional law. If I go into class and speak all day about March Madness or basketball, I am not fulfilling my contract. I'm going to be in trouble. Universities all the time make content-based discriminations. They're going to hire in this field, not on that field. They're going to give grants in this area and not in that area. Content-based discriminations are constant in a university. What about the idea that all ideas are equal? If the notion was all ideas are equal, university would be very different places than they are. I mean, we give tenure to people because they have good ideas. So we have lots of sanctions we apply for bad ideas. We give bad grades to students and so forth and so on. But the point is, we make evaluative judgments all the time. And what about not compelling speech? Well, most universities I know live under a rule of publish or perish. That means you have to speak. So the three rules which define the idea of freedom of speech under the First Amendment do not apply typically to professors in the area of universities. So what does apply? And what I'm going to suggest is a different model, what's called academic freedom. Academic freedom develops in Germany in the 19th century. It gets brought to this country in the early years of the 20th century. Its first great articulation is the 1915 statement, the Declaration of Principles of Academic Freedom and Tenure by the newly formed American Association of University Professors. And academic freedom says professors should be free to exercise their rights to speak, both in their professional capacity, in the classroom, in many different areas. But there is a difference between freedom of speech understood in a paradigm of academic freedom and freedom of speech understood in the freedom of speech paradigm. That's because the academic freedom paradigm starts with not with the idea of professors are political actors who have to form the public opinion for the government. The academic freedom model starts with the purpose and the goal of universities. The purpose of universities is to create new knowledge, to disseminate existing knowledge, and to teach. And the freedom that professors have to speak, which is consistent with academic freedom, as opposed to the freedom of speech idea, is the freedom to speak in ways which are consistent with those purposes and which are derived from those purposes. And that's a very different model, because that says if professors are speaking in ways that contradict the purpose, if they're incompetent, for example, they can be subject to sanction. So a good example of that is not giving tenure to a young assistant professor who writes bad work. That is inconsistent with the freedom of speech model we have under the First Amendment, because the state isn't supposed to be making evaluative judgments of that kind, but it's the daily bread and butter of a university. So the university can and will make judgments constantly based upon the speech of professors if it's consistent with the purpose of the university. Now, the accomplishment of the purpose of a university is measured in terms of the competence of the actors within the university. So whether I'm speaking in a classroom in ways that are consistent with professional competence is a matter of professional judgment. And because it's a matter of professional judgment, academic freedom teaches that these judgments cannot be made by people who are not academics. They have to be made by professionals, which is to say by faculty. And as a result of that, academic freedom is conceived not as the freedom of speech of the individual professor, but in the words of the 1915 Declaration, of the freedom of speech of the academic profession. It's a right that attaches to the profession, not to the individual, although it can be asserted by the individual. And what I want to suggest in this discussion is that freedom of speech for professors are better understood under the academic model than under the freedom of speech model.
Great, thank you. Mr. Dershowitz, I'm going to kick it off to you.
Well, thank you so much. When I used to finish teaching a class, my wife would ask me, did you have a good class? And my answer would be, yes, I learned something in the class from my students. So today I learned a good deal from Dean Post. And so it was a very, very good experience for me. Now, I'm so pleased that we have such a diverse array of speakers today. We have two white Jew men, both born in Brooklyn, both went to Yale Law School, both clerked for the same judge, David Bazelon, and both are experts on the First Amendment. So I hope that the lack of superficial diversity will be made up for by intellectual diversity. And I do have some fundamental disagreements. Of course, I completely agree that universities have to regulate speech in some degree. No professor in class certainly should be able to use any racial epithet or gender epithet in calling on a student. We would all agree with that. Where I found Dean Post's analysis incomplete for our purposes, at least, was it didn't focus enough on out-of-class statements not made by professors in their academic capacity, but using their academic credentials. So you get a professor at Northwestern University who's a great scientist, and on the side, he's a Holocaust denier. This is a real person. Or Professor Shockley at Stanford, who invented the transistor, won the Nobel Prize. But outside of class, he's a dysgenicist who believes in racial hierarchy. And we have to figure out what paradigm affects and influences decisions regarding that. Yale now has a situation that I'm involved in. Was a professor there named Dr. Brandy Lee, a psychiatrist, who was at the Yale Law School and at the Yale Medical School. And in her part-time, she was diagnosing public figures without ever having seen them, including me. She diagnosed me as having caught Donald Trump's psychosis because we both used the same word, perfect. I used it to describe, as in perfect attendance, my fidelity to my wife over many years. And he used it to describe a very imperfect speech, a very imperfect telephone call that he made to the president of the Ukraine, which he called perfect. And so Dr. Lee said that we both have megalomania, we're both psychotic, and Yale fired her, not for anything she said in the classroom, but for something she said out of the classroom, because it was alleged that she abused her role as a psychiatrist and her credentials as a Yale volunteer faculty member. So those are issues that are somewhat more difficult, because I agree with you, of course, in the classroom, we judge people on various merits that First Amendment would never allow in the context of opinions, although the First Amendment does allow it. Obviously, in occupational, we judge people for all occupations based on their free speech, and up to and including confirmation of justices to the Supreme Court. So I want to kind of talk about our differences by beginning with a story. And the story starts in 1992 when Harvard Law School had a terrible, terrible racist event occurred that you might imagine caused tremendous concern among the faculty and the students. And the dean decided to appoint a committee to decide what could and could not be said, both under academic freedom and freedom of speech. Harvard, though a private university, lives by the First Amendment. And the dean appointed me to the committee as the extreme representative of free speech I had called myself a presumptive absolutist. I presume that all speech is to be protected unless I can be persuaded by a heavy burden of proof the other way. And so we had our first meeting, and we all went around the table. I was called on, and I said, I have a proposal. I think Harvard Law School should devise and publish a speech code. Silence, shock. You're the civil libertarian. You want a speech code? I said, yes, I want a speech code because I'm a civil libertarian. I know that there are things that can't be said by faculty, by students, by administrators. We all know what they are. It's the Potter-Stewart statement. We can't define it, but we know it when we see it. We all know that a teacher calling a student by a racial or ethnic epithet is not permissible. But right now, we have a common law, and we have decanal discretion. If every dean were like Robert Post, I wouldn't be concerned about decanal discretion. But I've lived through deans that are not quite as sensitive. And when you have a common law, when you don't have a code, you have open-ended discretion by administrators and by committees to decide after the fact and in context what is permissible speech and what is not permissible speech, what is permissible academic freedom, what is not permissible academic freedom. And so I put our committee through the exercise of trying to create a speech code. Well, I don't have to tell you what the result was. We got past, no, you can't use racial epithets. That was easy, and we could list all the racial epithets if you want to do it. But then we got to academic discussions of various words, like the N-word, and we simply could not agree. We couldn't get past that. Is it ever permissible to use it? Was Professor Randy Kennedy allowed to use it because he wrote a book of that title? He's an African-American. Would a white professor not be allowed to use it? Same thing on issues regarding intelligence, grading, a range of other issues. You may, just to bring it up to date, remember that Slate Magazine just fired one of its podcasters for being caught on a Zoom saying that we should debate whether or not white people can ever use the N-word in the context of discussing racism and race. For raising that issue, for debating that issue, he was fired from Slate. Or Georgetown Law School. The dean of Georgetown Law School recently fired one professor and pressured another one to resign because the professor, again, was caught on Zoom talking about bemoaning the fact that her Black students didn't do as well as her white students. And for bemoaning that fact, she was forced to be fired after 17 years. She did it in a quasi classroom context. It was a class, and then the class was over. The Zoom remained on. She and her fellow teacher talked about it, thinking the students were off the Zoom. They were on the Zoom. And so these are the hard questions. And I don't think you could ever come up with a code that so occupied the field that no discretion outside of the code would ever be permissible. And that's exactly what happened in the thought experiment that we conducted at Harvard. We could come up with a few areas, but we could never come up with enough of them to say that nothing beyond this code could ever be a subject of discipline. I had an answer for it, but my answer was not accepted. And my answer was, if you have new things that you didn't think of, then you put them in the code prospectively. But what happens to the person who violated the code retroactively that we now want to apply prospectively? Well, the answer is he gets away with it, just the way people who violate what should be criminal laws, for example, in the area of technology, criminals are way ahead of lawmakers. And so they constantly are finding new ways of committing crimes, and we can't punish them. We can warn them, we can civilly sue them, perhaps, because civil is common law, but not statutory, but we can't punish them, but we can immediately make it a crime and punish all future. So we create a balance. The balance is it worth allowing some sinners to get away with their sins because we didn't think of them in advance and put them in a code? Or is it better to give deans and committees wide discretion to take into account all variables and apply them retroactively based on the currents of the time? Well, one problem is academic freedom and free speech are designed, are calculated to resist the attitudes of the time. They are supposed to be in some ways anachronistic. We don't want limitations on free speech to be based on current notions of cancel culture. We want free speech to be more enduring and to be more able to resist the winds of current fashion. And so, these are complex and difficult problems. And what I would say, and here I disagree again a little bit with Professor Post, he talks about the reasons we have free speech, and he gives a lot of very good reasons for free speech and academic freedom. I think he omits the most important reason for why we have free speech, and that is the alternative. The alternative for free speech means giving someone, somebody, some institution, the authority to censor. And so I would end my comments by paraphrasing Winston Churchill. Free speech isn't free. Free speech is very difficult. Free speech creates all kinds of problems, difficulties. Free speech is the worst possible solution to problems of democracy, except for all the other methods that have been tried over time. So for me, the case for free speech, the case for academic freedom, is largely a negative case. I don't buy the marketplace of ideas. I don't think the marketplace of ideas produces the best ideas necessarily. I don't buy many of the other rationales for freedom of speech, even some that were rejected by Professor Post, some were accepted. But I end up supporting free speech and supporting codification rather than decanal or committee discretion, because the alternatives are so much worse.
Great. Well, thank you for those opening statements, gentlemen. I want to begin by asking you both a couple questions that I think will help us narrow down on this. So the First Amendment applies to public universities, but we've also seen cases like the Supreme Court's Garcetti versus Ceballo, which held that public employees, when they're acting in an official capacity, don't have unlimited freedom of speech. There's a case coming up pretty soon, Meriwether versus Hardtop, and it's looking at a Shawnee State University professor who did not want to use the preferred pronouns of a transgender student was sued. Questions about whether or not that falls within academic freedom, First Amendment protections, or whether that falls under harassment. And so I guess I wondered for both of you, and we'll start with Mr. Post, specifically what court cases are you looking at? What judicial interpretations of the First Amendment and free speech support your viewpoint on the limits and also the extent of freedom that professors have on campus?
So, okay, that's a good question. Let me just respond. I mean, first of all, I want to say it's a successful class on two sides of this Zoom screen. I learned an awful lot from Alan's comments. I want to thank him for that. And I just, first I want to say about when Alan wants to focus, and it's a good thing to focus on, professors' speech outside the classroom about matters not typically within their academic expertise, or even if it is within their expertise. So first I want to give an account of academic freedom, what its components are. Then I want to turn, Jillian, to your question about a case like Meriwether in the context of a case like Garcetti. So academic freedom traditionally, as it's developed in the 20th century, and it's developed as a contract doctrine, not as a doctrine of constitutional law, because academic freedom is supposed to apply to all universities, and the Constitution doesn't apply, except, as you said just now, Jillian, to public institutions. So academic freedom is a contract doctrine. It's typically within the contracts of professors with their universities. It applies to four kinds of behavior. Classroom teaching. It applies to what's called intramural speech, which is the ability of professors to talk about what universities should do. It applies to freedom of research and publication, what you can research and what you can publish about your research. And fourth, it applies to what's called extramural speech, which is defined as a professor's speech outside of the confines of the university as a citizen. Now, it's curious, it's a difficult question why that should be academic freedom at all, because by definition, it's not about the field of your competence. And basically, it's like having a civil right to have your employment not depend upon what you say outside the university as a citizen. Most of us don't have that right in our work. In most states, I think in 48 states, an employer can fire you because of what you've said outside the term of your employment. And academic freedom is an exception to that, because it has had since 1915 this component of the professor can speak outside of the university, outside the field of competence, and be protected from reprisals based upon that speech. And the reason for it is typically that the university has to be a place where no one feels afraid. Because if you're feeling afraid, I'm speaking like Noam Chomsky about Israel, I'm a linguist, but I'm speaking about Israel, it crushes the atmosphere of freedom, which is so important for a university. That people should have that freedom to be vigorous, to say what's on their mind in exactly the way that Ellen was describing. And that's why it's typically said that extramural speech should be protected as a component of academic freedom, with one exception. If what you're saying in your speech as a citizen shows that you're incompetent in the area of your discipline, that can be grounds for sanction. But the threshold to do that is extremely high. And the explicit code, there's a code about this called the 1940 Statement, as amended by subsequent agreements between the AAUP and the ACA, say that normally it will not be viewed as relevant to competence, what you say as an extracurricular. So that's how academic freedom functions in the precise context that Alan was asking about earlier. Now, you, Jillian, brought up a case called Garcetti. And this raises a very important point about why we don't want a freedom of speech, generic freedom of speech paradigm here. Because when we speak about the freedom of speech paradigm, where we are imagining people getting together to talk about what we should do, forming public opinion, saying, we should invade Iraq, or we should get out of Afghanistan, whatever it is that we're saying. And we want the government to be responsive to us. So we don't know what we want to do. And we're talking to each other to decide what we want to do. That's the typical scene in which freedom of speech applies. But in a modern state, when you actually decide to do something, how do you do it? Typically, you create an organization to do it. So if I want to create a new Social Security Administration, I have to create the Social Security Administration. If I want to create medical services, I have to create a hospital or whatever institution is going to deliver the services that I have decided in public opinion to create. So what is it to create an organization? It's to arrange resources to accomplish the end of the organization. The end of courts is the dispensation of justice. The end of the military is national security. The end of a prison is either reformation or punishment or whatever we decide our purpose of prison is. The end of schools is to teach. So when you've created an institution and you have a purpose for those institutions, then what does the state do? It regulates the people in the institutions, including their speech, in ways designed to accomplish those purposes. And so the Supreme Court has said in many, many, many cases, if you're a government employee and you're speaking in ways that are inconsistent with what the government organization in which you're an employee is trying to get done, so much the worse for you. You have no First Amendment rights outside of achieving the purposes of the organization. We measure your speech by whether you are disrupting the organization. That's the underlying theory of the thing. And in Garcetti, the court went very far. They said, look, if you're speaking in your capacity as an employee, no matter what you're saying, you have no First Amendment rights at all. If you're speaking as a citizen, then we balance your rights as a citizen against the harm you're causing the organization. And the court in a case called Connick said, we put a huge thumb in the scales on behalf of achieving the ends of the organization. That's the background. Now, apply that logic to university professors in public institutions, we would have no right to say anything. If I said something that embarrassed a public institution, I could be fired for that reason under Garcetti. And we do that in other state organizations, like in a case called Roe versus San Diego. You have a police officer who's making kind of quasi-porno tapes and selling them on the black market afterwards. And the San Diego Police Department fires him, says you're embarrassing the police department. It's inconsistent with the respect and legitimacy and the dignity of the San Diego Police Department. And the Supreme Court says, yeah, of course, fire him. It's inconsistent with to speak in that way. So when we speak of First Amendment and you're in an institution, you don't typically have very many rights at all from the freedom of speech perspective. Now, the case that you just talked about, which is a recent Sixth Circuit, a case called Meriwether, I think came down last week, actually by an old student of mine from Berkeley, is the judge who wrote that opinion. And that's a case in which a professor said, I will not use the pronoun of choice, but I agree that I won't use any pronouns at all. I'll just use the last name or whatever. And it was stipulated in that case that there was no harm to the educational mission of the school. The student didn't feel discriminated against. There was no harm to the educational mission within the classroom. And nevertheless, the state decided to fire that person. It was a state institution. Now, I think it's a hard case for a state to make, to fire someone when they can't show that it's not disruptive. It's not against the professional norms. And once you have a factual record like that, then you have a case in which, one of those rare cases in which the regulation of speech in the classroom is extremely hard to justify. But when you're in a freedom of speech paradigm, you're fighting that battle with two hands tied behind your back, is what I want to say, Jillian.
But I think you're fighting that battle with at least one hand tied behind your back under the academic freedom paradigm as well. And let me mention those issues. You talked about one of the functions of the university is to make you feel not afraid to say various things. And of course, we now know that some of the greatest censorship on academic institutions and campuses comes from people who claim they feel unsafe. They feel afraid to express various points of view. We all know the case of my colleague, who you know, Ron Sullivan, who completely outside of the context of his academic work, he's a law professor. He was also the first African-American dean of a college at Harvard. Harvard is based on the college system. And he was not rehired, fired, basically. I mean, my colleague, Noah Feldman, says the difference between not hired and fired. No, there isn't. Not in this context. If it was discovered 30 years ago that somebody was gay and was not rehired, he would be fired. So I think we functionally can say Ron Sullivan was fired. Why? Because he was representing Harvey Weinstein, who was hated, despised. He had previously defended a tight end for the New England Patriots who was accused of murdering two people. And the evidence was pretty overwhelming that he did. But nobody in Winthrop House said they were afraid or scared or felt unsafe when the defense lawyer for a murderer or an alleged murderer was their dean. But when he was defending Harvey Weinstein, they suddenly felt scared or afraid. Now, we as professors don't like to confront students and call them liars, but I'm different. I do. And the students who claim they were afraid were lying. They were not afraid. They did not feel unsafe. They had learned the language of censorship. And the language of censorship requires them to use the academic freedom paradigm, fit into it, and say it's the mission of the university to make sure we feel safe and unafraid. So we're going to tell you we feel afraid and unsafe, and therefore please censor. And it worked. And the dean, not Dean Robert Post, but the dean of Harvard College, who didn't have any backbone, fired Ron Sullivan, thereby doing enormous damage, not only to freedom of speech and to academic freedom, but to the legal profession and the Sixth Amendment to the Constitution. And that's happening more and more. And the other area where I think we don't have enough strength in the academic freedom paradigm is freedom of speech, as we know, includes the freedom to listen and to hear. In other words, an audience may have the right to listen to somebody who has no right to express a view. The paradigm case, a case I consulted on many years ago, was when a foreigner wanted to come to the United States. He had been a communist and he was justly and appropriately under the law kept out, but the audience wanted him to be heard. Or recently at San Francisco State University, a terrorist, a convicted terrorist who was on the wanted list named Layla Khaled, who hijacked two airplanes, wanted to be heard by University of San Francisco students. She had no right under the First Amendment or academic freedom. She had no right to speak, but they had the right to listen. They had the right to hear. And under the free speech paradigm, the courts have recognized the right to listen and the right to hear. Academic freedom, I think, has diminished the right of students and focused much more on the right of faculty members. And I think that it's very important to recognize the right of students to hear controversial views, views that are unpopular outside the classroom and inside the classroom, particularly now where the classroom and the forum have become merged, where what goes on in classrooms today, particularly in some departments, now obviously not in physics, not in geology, but yes in history, yes in political science, yes in law in some respects, you have teachers using the classroom not to teach the students how to think, but to teach them what to think and to propagandize students. And there was a teacher, for example, at Columbia Law School named Professor Massad, who was a Palestinian American and very good, very expert in Middle East. And he called out a student in his class, and the student started to respond. And the teacher said, "Do I sense an Israeli accent?" And the student said, "Yes." "Did you serve in the Israel Defense Forces?" "Yes." "Well, you can't speak in my classroom unless you're willing to admit you committed war crimes." And so he shut the student down in a very ad hominem way. And the complaint in that case came not from the student who was shut down, but from other students in the class who wrote a letter or petition saying, "We want to hear from this student. You should not have the right to shut that student down." And so I think we have to add both to the academic freedom paradigm and the freedom of speech paradigm, the right to hear, the right to listen, the right to see, the right of the audience to receive, not only the right of the speaker to promote.
I think those are wonderful points, Alan. I quite agree with you on the Ron Sullivan case. I got into many debates here at Yale over that case. I thought I could not agree that that was a proper use of authority. I thought it was a misuse of authority for precisely the reasons that you state. I disagree with you when you say that the mission of the university under the academic freedom is to have students not feel afraid. That's totally not the mission.
Oh, I thought I was quoting. Sorry, I
No.
don't think mission at all. I agree with you. I thought
the mission is to make them think for themselves.
If I can jump in, it may be instructive for you both to say what you think the mission of the university is. And also on that note, I'd like you to assess how well they're performing it. Because it seems to me that you can have an organization that has a specific mission, but particularly under the academic freedom model, if it is co-opted by people who are in positions of power that have an ideological, political, or social or economic agenda, that can be a problem. And what do you do about that?
That's totally correct. I mean, the mission is to create students. I wrote this into the mission statement from the University of California, is to induce in students a mature independence of mind, to get them to think for themselves, to get them precisely to be able to deal with ideas they don't like, that might be threatening, and to handle them as rational human beings who are able to participate in the self-governance of the country. That's our object in modern education. You know, it's not the object of all higher education. There are theological institutions that are there to make you, good Christian gentlemen or good Jews or whatever. But when we talk typically where academic freedom applies, that's the function of higher education. It's to make the turn from late adolescence into adulthood and to give you the intellectual mastery and competence to think for yourself and to be able to handle people who disagree with you. What is a democracy? It's a place where people live who disagree with each other. So you're going to have to deal with people whom you don't like, whose ideas are, can be threatening, and learn how to handle that. That's the object of a good education. And so we need to act, and academic freedom would say, you need to act in a way that instills that in students. That's your job. That's our job. So when I'm in a classroom and there's a conservative or a liberal split and one side isn't speaking, I'll take that side. If the conservatives don't side, you always speak up for the side that's not speaking, because that's the job, is to get it out there in ways that people can see what's going on. So that's the measure, right? Certainly under the mission of the university, right? We agree on that.
Right. Yeah.
Right.
My easiest year of teaching criminal law was the year that Ted Cruz was in my class, because he walked into the class with his right hand raised, never put it down, and presented the arch conservative point of view on every issue.
Right.
Up until that time, I had to be the one defending the death penalty. I had to be the one defending all the other more conservative points of view, because I agree with you. Our job as teachers is to be the devil's advocate. But when you have the devil himself in the class, you don't have to be the devil's advocate. And so Bruce, he was a great student, really made my much easier. But I want to challenge you on one thing. Obviously, the university must keep students safe from any kind of physical threat. They must keep students safe from any kind of retaliatory threat. Even if it's retaliation, we won't give you a letter of recommendation. For example, when I was a student body president at Brooklyn College and I defended communists, the president of the university, the academic president, Harry Gideons, wouldn't recommend me to Yale Law School, even though I was first in my class at Brooklyn College, because he thought I was pro-communist. I mean, I hated communism, but I defended free speech rights of communists. That kind of retaliation should never be permitted, nor should any kind of physical intimidation. But nobody should protect students from being frightened, scared, afraid, unsafe in their ideas.
But you have to.
Yeah. Oh, let me just finish one point.
Sorry.
The question is immediate. We all agree on physical safety. We all agree on intellectual unsafety. And then there's this middle ground, emotional safety, where students are now focusing on saying, we're not worried that we're going to get beaten up. We're worried that we are going to be psychologically damaged by being in the presence of a professor who would defend Harvey Weinstein, or who would defend a white supremacist, or who would defend Donald Trump. And so you have to deal with that intermediate category, which is becoming more and more prominent in efforts to censor.
Yeah, and I think in part that's a debate over what the mission of the university is. When I was before the 1960s, the mission of the university was in loco parentis. We were like parents, and we were there to swaddle and protect our students. Then comes the free speech movement in 1963 in Berkeley, and the Constitution is amended, and suddenly students are adults, and we're no longer treating students in loco parentis, which means there are extreme boundaries about what kind of care we're supposed to give students. What I'm seeing in students now is they want the universities to be in loco parentis. They want us to be parents. When I was in college, I wanted to kill my parents. I was very Oedipal. Now students want us to be their parents. And this is a fundamental debate about the role of education. And what I want to say about this category that you put on the table, which is a good one, about emotional distress, in part, it's impossible to separate intellectual growth from distress. So distress is a concomitant of growing intellectually. But on the other hand, our job is that they be educated. And that means you have to take students where they are, and you have to work with them to get them to the place where they are mature adults. And so one has to take account of it. One can't ignore it. One can't just say, lump it or whatever. One has to address it and somehow bring. Education means to lead out of, to take them from where they are to the place where they are able emotionally to handle. And that's our job. And so what I want to say about this third category is we need to be able to structure an environment which can allow for the development of students. So the education is a developmental process, and you don't understand a developmental process under a regime of rights. Rights are not about a developmental process. Education is goal-oriented, and a developmental process, but rights are not goal-oriented. Rights are, you can do it or not do it. And so it's more subtle than that, in my view, in the context of the classroom for that reason, because we have the obligation to take them from one state of mind into another. And
so let's focus on a specific issue, and I'd be interested in your views. We both remember a great law teacher named John Kaplan. He taught at Berkeley, he taught at Stanford, he visited at Harvard. We were very close friends, and we talked all the time about teaching criminal law. One day he called me on the phone and said, "Alan, I found it." I said, "What?" He said, "The Holy Grail." I said, "What did you find?" "I found a criminal law casebook that doesn't cover rape. And I'm going to assign it for the rest of my teaching career, because previously all criminal law casebooks had rape. And so I either taught it and I got in terrible trouble because I'm a white male, and no matter what I said, I got all kinds of terrible grades and evaluations, or I skipped it and I got into terrible trouble. Why are you skipping it? But now the casebook doesn't even have it, so I don't have to teach it. Now, if you know John Kaplan, you imagine how he said that. and the humor and the enthusiasm with which he said it. But that's what's going on today.
Yeah,
Teachers
that's a bad
will
thing.
not teach that. They will not teach race. They will not teach gender. They are staying away from issues. Steve Pinker and I decided to take that on several years ago. We taught a joint course at Harvard College with 1,000 students called Taboo. And the only criteria for a subject being covered is it can't be discussed on college campuses. And so we had 15 subjects that could be discussed, and we discussed them. And it was very popular because most of the students, the quiet ones, the ones that aren't making the noise, really want to hear discussions of complicated issues, honest, heartfelt, difficult discussions. And yet they're very hard to have today at American universities.
There's no doubt about it. I mean, you know, the notion of the fetishism, fetish is the word I would use rather than taboo, because it has this incredibly powerful emotional impact and people are scared of it. And for good reason, because the emotional reactions triggered by certain things are just awful to deal with. So I teach constitutional law to incoming students, and I teach abortion, I teach race. I mean, I teach subjects which are really hard to teach. And the way I try to do it is I take whatever they think they know and I ask questions in ways that cut across their expectations that they don't have a ready answer to. In any case where they have a ready answer and they view it as threatening that answer, it's going to be hard to educate them because they're going to have this fetishistic reaction. So the object of good teaching to me is to find a way around that, and that is to approach the subject from behind, where they don't know what they want to say. And then as they start implicating themselves in what they haven't thought about, suddenly it begins to impact what they thought they knew.
I agree. What I tried to do too, it's getting harder and harder to do it.
It's hard to do that. I agree with that. But that, you know, to me, that's our, you know, we take students where they find them. That's our job.
Yeah.
May I make one other point before, when you talked about the right to know? So you're right that there is this sense within First Amendment doctrine, freedom of speech, the right to know. It's most fully developed in the context of commercial speech, where the speaker didn't used to have a right, but the audience did have a right to receive the commercial information, which advertising gave. I think the interesting thing in the academic freedom paradigm is that we don't really have any account of academic freedom for students. The Germans did. They had a Lernfreiheit as well as a Lehrfreiheit. Lern was of the students. In the United States, academic freedom for students is just a negative image of academic freedom for professors. And I think there are good reasons for that in the United States. And one of them is it's very hard to understand what the right is of students to know. So if I teach a class and I'm teaching, you know, I have 12 sessions and I decide I am not going to teach, I don't know, pick an example, the right to die under the Constitution, but I am going to teach abortion. A student can't come to me and say, I have a right to know the right to die. Similarly, if a student says, I have a right to hear X professor, you have to invite him to the university. There's no such right. Right? So the right that the student has is the right to an education, which is that those who know how to educate are doing a good job educating. And that's different than indoctrination. You're quite right.
Let me give you an example from your old university and how your successor saved the day. So for years, pro-Israel groups at Berkeley wanted to invite me to speak, and I offered to come and speak. We established a date when I could be there. They didn't have any money to pay, even expenses, so we wanted to do it at a time when I was in the area anyway. And Berkeley had just established a rule saying that unless you're invited by a department officially, you have to wait 8 weeks to speak. That would have made it impossible for me and others to speak. Every department had invited anti-Israel speakers, Norman Finkelstein, you name it, every anti-Israel speaker had been invited. So the student group that invited me went to every single department at the college, and every single department refused to invite me. So I drafted a lawsuit saying that Berkeley, a public university, had created a system under which content was being considered as a form of censorship. As soon as Erwin Chemerinsky heard about it, he immediately invited me on behalf of the law school. And of course I went, had enormous crowds. Antifa tried to interfere with my speech. People stayed. I said I would stay as long as there were no more questions. I invited the protesters to come in. And that was a situation where the school had a rule precluding the professor from speaking, the guest from speaking. But I was going to argue that the students who invited me had the right to invite me and the right to hear me. And so I think it's different. I agree with you. We had a test case at Harvard a few years ago. I'd be interested in knowing what you think of this. So Professor Duncan Kennedy, who taught contracts and had no expertise in the Middle East, but he's a lefty. And of course, if you're a lefty, you have to give a course that's anti-Israel and pro-Palestinian. Otherwise, you can't join the left. So he decided to give a course on Israel and Palestine, knew nothing about it, and created a syllabus that was totally, completely, absolutely one-sided. One of the students, who had been my student, registered for the course and said, Professor Kennedy, these are one-sided readings. Here are a group of readings. He didn't even assign my books. My books are advocacy books. They're not scholarly books. The Case for Israel, The Case for Peace. Well, I wrote about 6 books on Israel. He didn't ask to have any of those, but very, very scholarly books down the middle. And Kennedy said, no, it's my class. I'll decide what to assign. And the student said, Professor Kennedy, welcome to the 21st century. And what my student did is he put online alternate readings for every single reading that Professor Kennedy had assigned. And by the end of the semester, more students were reading the alternate readings than were reading Professor Kennedy's reading. So there you had a situation where a student, and he was supported by other students, fought back against a professor who was using his classroom as a political platform and prevailed. So students have weapons available to them. I never asked my student what grade he got. That would be interesting to find out, but he wasn't interested particularly. And as we move away from grading, I think that becomes less of an issue in any event. But these are serious problems today. And we have reports of students from all over the country feeling that they're being propagandized in the classroom by professors who come in with an ideology. There's a tape recording that somebody made of the American Linguistic Society a few years ago. And on the tape, it has a professor saying, we must make the case for Palestine in every class, in math, in science, in physics, in linguistics, and it's on tape. And, you know, could a professor be fired for doing that? I mean, those are—
The answer is yes.
Yeah.
That's an easy question. You know, if a professor's teaching mathematics and spending their time making the case for Palestine, they can be fired. And academic freedom doesn't protect that. And it shouldn't.
I'm going to interject here because we're getting some questions from our audience on exactly this topic. And a lot of them are saying that they're looking at studies about the ideological bent of universities, the number of professors that lean left versus the ones that lean right. And we're also hearing a lot about how students on the right in particular feel the need to self-censor in class because they will face academic and social repercussions. And then also students on the left are afraid of this. I look at Evergreen State University, which had a big campus controversy a couple years ago. Their students are to the left of Berkeley and ended up saying that they felt like they couldn't speak on campus. So if you've got this culture where professors are becoming increasingly activist, increasingly political in their content, and where other students will use Title IX harassment policies to target the speech of other students, under the current legal framework, how do you respond to that?
You go first this time, Ellen.
Well, I think it's challenging. I think that if it's a public university, you have obviously greater options than if it's a private university. Dean Post is correct that private universities, your rights are mostly contractual. Dr. Branding Lee is suing Yale under contract, academic freedom contract. There are now provisions. You remember that President Trump, whether you agree with anything he did or disagree with everything he did come up with an executive order which broadened the obligation of universities, private universities that receive any federal funding, to treat anti-Semitism in the same way as it treats racism and phobia and sexism. And so there are administrative remedies for some of these issues, but they're very difficult to come by. And you know, harassment has become, again, like fear and unsafe, and has become a method of achieving censorship. And it's used by both sides. But I'd be really interested in how the dean would respond to the first part of the question, because I'm very troubled by that, and I don't think there's an answer to it. It is a fact that the vast majority of academics, certainly the vast majority of professors at Yale Law School, Harvard Law School, Harvard College, Yale College, Berkeley, the vast majority are liberal Democrats. I remember when I came to Harvard in 1964, I was the most liberal, the most left person on the Harvard Law School faculty, very conservative faculty. By the time I left, I was in the middle, kind of closer to the right than the left, although I hadn't changed at all. I was still a civil libertarian, a presumptive absolutist, voted for every Democrat, never voted for a Republican. But you can't have a test. It would be wrong to try to have academic diversity based on political affiliation. So, Dean, how do you deal with that problem when a fair application of academic freedom results in the not only overwhelming majority, but 90-10 or 92-8, as some of the statistics show, in favor of liberal Democrats? Not that liberal Democrats are a single group. Obviously, there's a tremendous division of diversity among liberal Democrats, but the perception by conservatives is that they don't get a fair shake at universities today. How would you address that problem? I find it unsolvable.
Mr. Post, I'm actually going to jump into with a question because we're getting this from some of our viewers.
Okay.
So they're saying under the academic freedom model that you're describing, presumably you'd have educated administrators, educated faculty, deciding where those lines of appropriate speech or what's legitimate research or legitimate educational content are. But I'm getting some questions about the concept of deplatforming, that there are some speakers that you don't need to invite, that you can take away the microphone for wacko speakers or people on the fringe, and that's not a free speech violation. But I think the concern here is that if you have gatekeepers that are all of one political bent, and if they begin defining more and more speech as off limits or as fringe when actually it's mainstream, how do you deal with that? How do you make sure that freedom of inquiry and open discourse is still protected?
I think you do it by having a good sense of what your mission is. Your mission is to prepare students to live in a diverse world, and if the students are in an echo chamber, they're not prepared to do that. So the fulfillment of your mission is precisely to prepare them for a world in which people are going to get out there and they're going to disagree in fundamental ways, and that's the object of let's put it this way, of a humanities education now. It ought to be allowing people to understand really the kind of world they're living in. That's not putting a test on who the faculty is. That's putting a test on the competence of their teaching. Now, it seems to me a confusion to equate that sense of mission, and which it's the responsibility of administrators to instill in the faculty with a rights regime. So I've often heard it said in exactly the way you put the question, it's somebody's right if they get refused an invitation to a university, their right is violated. It can't be right. Nobody has a right to go into a university system and give a speech. You are invited into a university. Why are you invited? You're invited because presumably you will serve the educational purpose of the university. Otherwise, the university has no business inviting you. Otherwise, it's a frolic and a detour, and it's wasting the university's money. It's a waste of public resources for a public university, right? So the only reason speakers are invited onto campus is that for one reason or another, on one account or another of the mission of the university, it serves those purposes. From the outside, if I'm saying, gee, I want an invitation to Princeton, I have a right to be invited to Princeton. No, I don't have a right. Princeton can invite who they please. Now we make a judgment. Are you inviting the people that are serving your mission? This is not a question of rights at all. It's a question of evaluating whether Princeton is serving its mission by inviting the spectrum of people that it's serving. And the typical way that universities do that is they divide speakers into different classes. So if I invite a speaker to my class, it's because it's serving the educational function of my class. And if an administrator says to me, you can't do that, then it's a matter of my academic freedom that I say this person is, and the administration says it isn't. And under the academic freedom model, the faculty win over administrators. Administrators do not make this judgment. Faculty make these judgments. But most universities have a different class of speakers. They're not invited by the university itself or by faculty. They're invited by student groups.
Right.
So typically what happens is university gives a budget to a student group and they say, you invite who you please. Now, it's an interesting question how giving budget to a student group and not even knowing who they're going to invite serves an educational function. One needs an explication of that if it's not just wasting university resources. And the best explanation I can think of is that we've settled on this pattern because the university, by allowing different student groups and by giving the money to different groups of different orientations and different viewpoints, reproduces the diversity of views you would see actually in a democracy. And so it socializes its students to that kind of diversity. Again, that's the function of giving the money to the students to invite who they please. It's nobody's right. One doesn't get anywhere in this situation by imagining that someone outside the university has a right to do it. One gets somewhere by saying, what is serving the function of the university by giving this budget? And then we have to stand by that purpose, however we explain it.
So let me challenge you on that. If you came to the conclusion as the Yale Law School or anywhere else, that the university's mission is not being served by having this skewed number of liberal Democrats over conservative Republicans, and that you think the mission of the university would be better served by having an affirmative action program in which you lowered the standards somewhat. I don't think you would have to lower the standards in my view, but if that's what affirmative action means, lowering the standards somewhat or not applying exactly the same standards or seeking more aggressively the people you want, and however you want to define that, in so as to create a better balance of conservative Republicans, would you favor that? Would you favor that?
I would do that. You know, if I thought my student groups were not giving the kind of menu of speakers, I would put it in from the dean's perspective, because then I want to make the menu what it's supposed to do.
I'm sorry, I misspoke. I meant in hiring faculty.
Oh, no.
No, so here's my point.
Absolutely not.
You decided there's 100 faculty members. 90 of them are Democrats. 98 of the 100 are anti-Trump. 40% of Americans, 45% of Americans voted for Trump. And you came to the view that the university's mission would be better served if instead of it being 92-8, it was really 80-20. Would you more aggressively search for conservative Republican faculty members who are equally good or almost as good? Would you make that an element of your hiring process?
Absolutely not. And that is because I define the mission of the university not by anything political, like whether the person is a Democrat or not, but by whether they're competently doing their job, which is to say fulfilling their disciplinary standards. So let's take an easy case. You know, I mean, maybe 50% of the population are creationists. It doesn't mean that for a minute you think of hiring someone in the biology department who's a creationist. You'd hire someone in the biology department who meets the standards of a good biologist, and then you let it play out wherever it plays out. From my point of view, this is where I started, you know, when I was saying I don't like getting these things in the maws of partisan disagreements. I think partisan disagreements are absolutely 100% irrelevant to the competence of somebody in doing their job. I don't care whether the constitutional person I'm hiring is a Republican or a Democrat. If I didn't know, I would rather not know.
Okay.
I'm just looking at the quality of the work, period. End of story.
Challenge you on that. Do you think it is a complete coincidence that 92% of faculty members are liberal Democrats? I mean, there are only two possible ways that could come about. One, liberal Democrats are smarter, more academic, better suited, desire to work in universities more than people on the conservative side. In other words, they're better. That's one possible explanation. And I don't buy that. I mean, there was a time in my life before I got to know conservatives when
You'd think. Here we go. Looks like they're getting the green back up.
Three of us are doing fine. We hear
I know.
I'm really enjoying it.
Gentlemen, you're back.
Rights are being protected. For listeners to hear that not being protected.
You're back now.
Okay. Where did you cut off so Alan could pick up?
How do you explain this enormous, first of all, you can't disagree with my facts. The facts are the facts. There is this enormous disparity. Now, it either means that conservatives aren't as smart or as academic or as motivated or as inclined to go into academics, or there may be a thumb or a pinky on the scale. How do you explain it?
Well, you know, I think there are many factors. I mean, among them are self-selection biases. For many, many years, conservatives wanted to go to Wall Street. They wanted to go to investment banking. They didn't want to go to academics because actually go to academics, you're relatively poor. And they were imbued with entrepreneurial ethics. And that's not an academic position. If you're, if you're entrepreneur, there are a lot of, so there's self-selection biases. I think in the real world, of course, the schema that I put on the table are corrupted by impermissible factors. And insofar as they're corrupted, then the corruption should be rooted out. I mean, there is no human institution that isn't corrupt since we left the Garden of Eden. And that just tells you what it is that you should avoid, you should try to correct in the institutions of which you're a member, that's all. So
let me
a couple of things.
More directly. Isn't the function of the university, shouldn't the university, by its function, be more interested in intellectual diversity than racial diversity? Racial diversity is very important, very, very important. Gender diversity is very, very important. But if you focus just on the role of the university, isn't intellectual diversity at least as important?
I deny that totally. I mean, I think intellectual diversity is exactly wrong, because that says that there is an interest in difference for the sake of difference. So if I teach Kant, I also have to teach Hume. If I teach Hume, I also have to teach Bentham. No, I don't have to teach Heidegger because I teach Kant. Rather, the diversity that one is required to teach is the diversity of a competent teaching of a subject matter. So if you want to know constitutional law, you need to know what originalism is, and you need to know what living constitutionalism is. And you can't be literate unless you know both those things. So that is not intellectual diversity. That's a competent display of the range of views which a competent person would know in an area. And to call that diversity, which means you're interested in difference for its own sake, seems to me exactly, I mean, I object to it. I think it's wrong.
If I were a student at Harvard, I would rather have Professor Tribe teaching me alongside Professor, you name it on the other side, Scalia when he was a professor, or some other people from the Federalist Society. I don't trust Tribe to give both sides of the originalist living constitution view. And I think students who have only Tribe, because only the tribists get to teach at Harvard, and the other people don't get to teach at Harvard because Harvard thinks that Tribe's ideas are better than Scalia's ideas. And I don't know how you judge that. It's very, very difficult to judge that. The students are getting shortchanged by hearing diverse views from a non-diverse person who really doesn't believe in the other view that he presents.
Yeah. So, but I think that's a matter of educational philosophy. So there are some schools like Chicago Economics Department that concentrates on one view, and knowing that in the world of economics departments, there are many different views. If you don't want that view, you don't go to Chicago, right? Mm-hmm. So some schools concentrate on teaching the range of possible views according to the educational philosophy you set forth. They want one of each of the relevant, and I mean relevant, not by diversity, but relevantly, material views. And others say, we're going to be the blah-de-blah school of contracts, and we're just going to have this sort of contracts. And, if you don't like it, you can always go to a different contracts department, right? So in America, in higher education, actually, there's different views on that question precisely. And I think, how do you settle the difference in views? You settle it over a question of, let's talk about how we fulfill our educational mission. And that's, again, not a question of rights. That's a question of what we mean by education and how best to accomplish it. And I think that's the right conversation to be having.
Well, I think we're having that conversation, but I'm not satisfied that we've come to a conclusion that makes comfortable conservative students who don't think that they are getting, that the universities are satisfying their educational mission because they're not presenting them adequately with, put it aside diverse, with the competing views which are equally compelling. And, it's hard to tell a student who doesn't know about this, don't go to Yale because it only presents one view, go to Chicago because it presents a different point of view. From the point of view of universities in general, that creates the kind of diversity we want. But for the student who's in one place and is only going to get educated in one place, that student, I think, has the right to hear a variety of competent academic perspectives presented. And I hear complaints from students all the time that when they go to law school, they don't get those views. They get them outside the class. They get them in the Federalist Society. They get them when they go to conventions. They get them from reading books, but they don't get them in the classroom.
Yeah, well, I mean, it's very interesting in the way you frame that is, we started with students are afraid of hearing certain kinds of insults, and now we're dealing with the fear of a different kind, which I'm not getting. So I'm suspicious of starting with the fear of a student of anything. What I want to start with is it's our obligation to give them, measured by competent education, something. So I wouldn't start where you started, but I would measure it in terms of what we give by our judgments as competent experts in the area of constitutional law or biology or whatever it is.
But for me, the results have to be judged in some ways empirically. And
Yes.
if the result is that students are being educated in one theory and one approach and are not getting an adequate education in other approaches, that shows to me that the educational mission is failing and we should be doing something about it. You reject any kind of affirmative action. I agree with you on that. And that's why I say the problem is insoluble. And we have to get to a deeper root. Maybe the answer is conservatives should stop trying to make money and move more into academia. And that would be a good thing for everybody. And let the liberals make some money for a change.
Yeah, poor professors like me would love to have that. It's a kind of Schadenfreude. I just lost my thought. I think in point of fact, what I was going to say is I think in point of fact, many institutions are sub rosa doing what you're describing. They do have a form of affirmative action because they do want to provide the kind of education you're talking about. And I can see it in hiring practices.
That's interesting. I was not aware of that.
All right, gentlemen, with that, I'm afraid we have to wind down the debate. We're out of time, but I appreciate you both taking time to talk to us. And thank you all who are viewing online. Thanks.
You're great moderators. Thank you.
Thank you, Jillian.
All right. Thank you to Professors Dershowitz and Post and to Jillian Melcher for a great discussion this evening. To all of our audience members, both in person and watching online, this video will be available on Steamboat Institute's YouTube channel and Facebook page. We understand there were some audio issues tonight. For those of you watching online, those will be cleaned up in the version that will be available for viewing afterwards. We apologize for that. Thank you again to Earl Wright and AMG National Bank for hosting us this evening here at the Dome in Greenwood Village. Please remember to visit steamboatinstitute.org. Follow us on social media. Please remember that your support is what makes debates like this possible. So it's really important that we bring these robust debates and discussions to campuses and communities all across America. Thank you and have a good evening.
Thank you.
Thank you. Thank you, Alan.
Thank you, Bob. Right.